Kenosha County Sheriff's Office says it has no merit and it should be dismissed. Rittenhouse is facing murder and attempted murder charges in the state of Wisconsin.
Some people, including President Trump, have suggested the shootings might have happened in self-defense.
You saw the same tape as I saw, and he was trying to get away from them, I guess, it looks like, and he fell, and then they very violently attacked him, and it was something that we're looking at right now, and it's under investigation, but I guess he was in very big trouble. He would have been, he probably would have been killed, but it's under investigation.
Attorney General Josh Kaul has another view of the shootings.
We need to be clear that violence, no matter what the motivation, is unacceptable. Violence and destruction in our communities is not acceptable.
Fox 11's Sierra Trojan investigates what qualifies as self-defense in Wisconsin and what doesn't.
This is 17-year-old Kyle Rittenhouse, armed with a semi-automatic rifle in Kenosha last week. He told a videographer with the Daily Caller that he went to Kenosha to protect businesses from protesters.
People are getting injured, and our job is to protect this business, and part of my job is to also help people. If there's somebody hurt, I'm running into harm's way.
He's accused of shooting and killing Joseph Rosenbaum and Anthony Huber and injuring another man. The criminal complaint says Rosenbaum followed Rittenhouse into a used car lot, threw a plastic bag at him, then attempted to take his weapon. A witness says Rittenhouse shot Rosenbaum. Authorities say Rittenhouse was then chased down the street by several people when he tripped and fell. The complaint says Rittenhouse allegedly shot Huber when he tried to take his weapon and shot a third man as he approached with what appeared to be a handgun. Rittenhouse's lawyer says his client was acting in self-defense. So how would a self-defense claim play out in Wisconsin? In 2011, the Wisconsin legislature expanded on self-defense law with the Castle Doctrine.
Wisconsin already has a self-defense law that looks at the reasonableness of the conduct of the person who feels threatened, the amount of force they use, whether it's necessary to protect themselves.
The Castle Doctrine allows you to use deadly force as a form of self-defense in 3 places:
your home, your vehicle, or your place of business.
Attorney Craig Kubiak specializes in firearm law. He's also a concealed carry instructor.
If you are in one of those places and somebody is trying to unlawfully and forcibly enter into one of those 3 areas, you have the ability to use self-defense to stop them at that point.
Kubiak says the difference between a traditional self-defense case and the Castle Doctrine comes down to the burden of proof. In a traditional case, the person who allegedly acted in self-defense must prove that their actions were justified. The Castle Doctrine is different.
The law is going to presume that you acted appropriately, unless the state can prove otherwise.
Under Wisconsin's version of the Castle Doctrine, you don't have to retreat before defending yourself. But Kubiak says it's something the court will take into consideration.
That's going to be something that the court is going to look at in the totality of the circumstances. So the jury is going to be able to consider, was it reasonable for you to do what you did, or did you have the ability to avoid the conflict altogether?
UW-Madison law professor Cecilia Klingel teaches courses in criminal law. She says the Castle Doctrine doesn't apply to public spaces, which is where Rittenhouse allegedly shot 3 people.
That provision, as best I can tell from the facts that are on the table now, wouldn't apply to this case.
Wisconsin Senate Minority Leader Janet Bewley voted against the Castle Doctrine in 2011.
With Castle Doctrine, the presumption is there that that person felt bodily harm or imminent threat. We have court systems that are meant to investigate. And I think that this use of the Castle Doctrine limits where investigation can go.
Bewley says she doesn't want to see presumptions in Rittenhouse's investigation.
The presumptions that people have should not automatically be held as true. You must examine the intentions and you must examine your own judgments before you make a conclusion.
As for Rittenhouse, it could be weeks before his lawyer outlines his case for self-defense. He's being held in an Illinois jail and will have an extradition hearing at the end of the month. For Fox 11 Investigates, I'm Sierra Trojan.
The Castle Doctrine passed overwhelmingly back in 2011 with a Republican-controlled legislature. We also spoke to Republican Assemblyman Ron Tussler about his thoughts on the doctrine.
I believe the jury system. I think you need to have some neutral parties look at a situation and try to apply the law appropriately. And, I think that would be how the Castle Doctrine or self-defense laws should be applied to, Kyle Rittenhouse and anybody else.
You can find this story and other recent investigations into the U.S. Postal Service and the COVID-19 pandemic on our website. Just head to fox11online.com and click on the Fox 11 Investigates tab. Oconto County health officials are concerned about the upcoming holiday weekend.
What they're worried about specifically, visitors